The Supreme Court reiterated that administrative rules and regulation must be published if their purpose is to enforce or implement existing law pursuant to a valid delegation. And the only exception for that is that if those administrative rules are interpretative regulations, and those are merely internal in nature. Welcome to the LawKey podcast, where you can listen and review case digests and get practical tips on how to survive law school in the Philippines. Studying law can be very challenging, especially for working students, but with the right tools, the right habits, and the right support group, we can surely survive it. This is Kim, your host, and I hope you enjoy and learn something from this episode. Here we go. Hi everyone! For today's episode, we will be discussing about Philsa International Placement and Services Corporation versus Honorable Secretary of Labor and Employment. This is under GR number 103144, decided on April 4, 2001. Now, this case was primarily given to us by our professor under the Persons and Family Relations subject. So let's start. The facts of this case are the petitioner, which is the Philsa International Placement and Services Corporation, is a domestic corporation engaged in the recruitment of workers for overseas employment. So on January 1985, private respondents Vivencio de Mesa, Rodrigo Miquin, and Cedric Layson were recruited by Philsa for employment in Saudi Arabia. So they were required to pay placement fees in the amount of 5,000 for private respondent Rodrigo Miquin, 6,500 for each private respondents Vivencio de Mesa and Cedric Layson. Now, after they have executed the said contract, the said private respondents left for Saudi Arabia on January 1985 and began working for Al Hajilan Consultants AE, which is the foreign principal of the petitioner Philsa. Now, on February 4, 1985, the private respondents were allegedly made to sign a second contract, which has some provisions resulting to reduction of some of their benefits and privileges. And on April 1, 1985, their foreign employer also forced them to sign a third contract, which increased their working hours from 48 hours to 60 hours a week. This is without any corresponding increase in their basic monthly salary. Now, when the three private respondents refused to sign the contract, their services were terminated by Al Hajilan and they were repatriated in the Philippines. Now, upon their arrival in the Philippines, private respondents demanded Philsa the return of their placement fees and for the payment of their salaries for the unexpired portion of their contract. So the respondents filed a case before POEA against Philsa. Now, the said case has the following causes of action. First, illegal dismissal. Second, payment of salary differentials. Third, illegal deduction or withholding of salaries. Fourth, illegal exactions or refund of placement fees. And the last one is contract substitution. So this is not related to the Persons and Family Relation subject facts, but just to give this one as an information or FYI to our listeners out there. Now, the agency who will be working on the first two cases, which are the illegal dismissal, the payment of salary differentials or payment of salary differentials, will be the Workers Assistance and Adjudication Office, because they are in nature of money claims arising from the employer-employer relations. Now, the last two causes, illegal exactions or refund of placement fees and contract substitution, these are in nature of recruitment violation, will be investigated by the LRO or Licensing and Recruitment Office. So The third one, which is the illegal deduction or withholding of salary, it is both money and a violation of recruitment regulation, and is thus under the investigatory jurisdiction of both AAO and the LRO. Now, there were several hearings conducted before the POEA officer on the two aspects of private respondents' complaint. And during these hearings, private respondents supported their complaint with the presentation of both documentary and testimonial evidence. And however, the petitioner, which is Philsa, actually failed to present its own evidence. That's why on the aspect of the case involving the money claim arising from the employer-employer relations, the POEA rendered a decision August 31, 1988, which says that judgment is hereby rendered ordering Philsa to pay complainants jointly and severally with its principal Al-Hijalin the following. So first is 2,225 to each complainant to the refund of their unpaid separation fee or separation pay. The second one is 1,000 Saudi Riyal for the Mesa alone, representing the salary deduction from his March salary. The third is 2,000 Saudi Riyals for Mikin and Layson for their differential pay for the months of February and March 1985. And the last is 5% of the total awards and by way of attorney's fee. Now, the said order was actually appealed by both the petitioner and private respondent. They filed separate appeals on August 31, 1988 to the NLRC or National Labor Relations Commission. And then the NLRC modified the said appeal by deleting the award of salary deductions and differentials because according to the NLRC, these were not raised in the complaint filed by private respondents, and then said so there was nothing in the text of the decision which would justify the award. Now, the private respondents actually had this one appealed to the Supreme Court, but then the petition was dismissed for the insufficiency in form of substance, for having failed to comply with the rules of court and circular number 188 requiring submission of a certified true copy of the questioned resolution dated August 28, 1989. Now, on August 29, 1988, the POEA actually promulgated a separate decision regarding the recruitment violation aspect of private respondents' complaint. In this order, the POEA found petitioner Philsa guilty of illegal exaction, contract substitution, and unlawful deduction. And moreover, the POEA said that Philsa is liable for 3 counts of illegal exaction, 2 counts of contract substitution, and 1 count of withholding or unlawful deduction from salaries of workers. There, the said petitioner's license is hereby suspended for 8 months. So the said petition was actually appealed from the POEA through LRO and then Ministry of Labor and then the Secretary of Labor. And since both the Ministry of Labor and the Secretary of Labor actually denied the petition of Philsa, then this instant petition was submitted by the petitioner. So let's go to the issue. The issue here, which is related to the persons and family relations subject, would be whether or not petitioner Philsa can be held liable for illegal exaction, considering that the POEA Memorandum Circular Number 11, Series of 1983, is void for lack of publication. Now, according to the Supreme Court, this argument is with merit. They mentioned the the case of Tanyada versus Tuvera, where the court held that we hold, therefore, that all statutes, including those of local applications and private laws, shall be published as a condition for their effectivity, which shall begin 15 days after publication unless a different effectivity date is fixed by the legislature. So the presidential issuances covered by this rule, according to the Supreme Court, are presidential decrees and executive orders promulgated by the president in the exercise of the legislative power whenever the same are validly delegated by the legislature or, at present, directly conferred by the Constitution. So these are the administrative rules and regulations which must also be published if their purpose is to enforce or implement an existing law pursuant to a valid delegation. Now, if they are interpretative regulations and those merely internal in nature, the said need not to be published, and neither is publication required for the so-called letter of instructions issued by the administrative superiors concerning the rules or guidelines to be followed by their subordinates. Now, POEA, Memorandum Order Number 2 Series of 1983, which is the questioned administrative order, actually provides for the applicable schedule of placement and documentation fees for private employment agencies or authority holders. And this was issued in compliance with the provisions of Article 32 of the Labor Code, which provides that Article 32. Any person applying with a private fee charging employment agency or employment assistance shall not be charged any fee until he has obtained employment through its effort or has actually commenced employment. Such fee shall always be covered with the approved receipt clearly showing the amount paid. The Secretary of Labor shall promulgate a schedule of allowing fees. So it is thus clear that the said administrative circular is one of those issuances which should be published for its effectivity, since its purpose was to enforce and implement an existing law, which is the Article 32 of the Labor Code. So the Supreme Court said that POEA Memorandum Circular Number 2 Series of 1983 must be likewise be declared ineffective, as the same was never published and filed with the National Administrative Register. So again, the Supreme Court ruled that the POEA's Memorandum Circular Number 2 is one of those issuances which should be published for its effectivity, because the purpose of the said circular was to enforce and implement Article 32 of the Labor Code, which is an existing law. And since this specific circular number 2 wasn't published, then the petitioner should not be held liable for illegal exaction because of this law. Now, the Solicitor General, however, contended that questioned administrative circular is not among those requiring publication contemplated by the case of Tanyada versus Tavera, as it is addressed only to a specific group of persons and not to the general public. The Supreme Court said that this argument has no merit. According to the Supreme Court, the fact that the said circular is addressed only to a specified group, namely private employment agencies or authority holders, does not take it away from the ambit of our ruling in Tanyada versus Tavera. They have mentioned another case, which is Philippine Association of Service Exporters versus Torres, where the administrative circulars questioned on those cases were actually addressed to even smaller groups, such as the Philippine and Hong Kong agencies, which are engaged in recruitment of workers for Hong Kong. But still, the court ruled that the said circulars may not be enforced or implemented due to lack of publication. So The Supreme Court reiterated that administrative rules and regulation must be published if their purpose is to enforce or implement existing law pursuant to a valid delegation. And the only exception for that is that if those administrative rules are interpretative regulations, and those are merely internal in nature, or letters of instruction issued by administrative superior concerning the rules and guidelines to be followed by their subordinate in the performance of their duties. So that's according to the Supreme Court. Now, those are merely the issues related to the persons and family relations subject, but we also have another issue here that I wanted to discuss just in case. So the first one is whether or not petitioner charged private respondents placement fee in excess of that allowed by law is clearly a question of fact, which is for public respondent, which is the POEA, as a tier of facts to determine. So according to the Supreme Court, it is a settled rule that the factual findings of quasi-judicial agencies like the POEA, which have acquired expertise because of their jurisdiction is confined to specific matters, are generally accorded not only respect but at times even finality if such findings are supported by the substantial evidence. So in this case, the Supreme Court said that it is clear that the ruling of the POEA saying that the petitioner is guilty of illegal exaction is supported by substantial evidence. And aside from the testimonial evidence offered by private respondents, they also presented documentary evidence consisting of receipts issued by an authorized representative of Philsa. And in contrast, the petitioner did not present any evidence whatsoever to rebut the claims of private respondents. So that's what the Supreme Court said on this case, in this issue, specific issue. Now, there's also another issue raised by the petitioner. They wanted to review, or they wanted the Supreme Court to review the findings of fact that the POEA regarding the 2 counts of alleged contract substitution. Again, the Supreme Court said that this is actually a question of fact which may not disturb if the same is supported by substantial evidence. So, a reading of the August 29, 1988 order of the POEA shows that indeed the ruling that petitioner is guilty of 2 counts of prohibited contract is supported by substantial evidence. So according to the Supreme Court, the decision of the POEA, since this is actually a question of fact, and the decision of the POEA was supported by the substantial evidence. Hence, the Supreme Court should not interfere of the said decision. They also added that the mere intention of respondents to increase the number of hours, even if there was a corresponding increase in wage, is clear violation of the contract as approved by the administration, and notwithstanding the same, the amendment is evidently contrary to law, morals, good customs, and public policy. So, the last issue would be the petitioner actually argues that the public respondent committed grave abuse of discretion in holding petitioner liable for illegal deduction, withholding of salaries, considering that the Supreme Court itself has already absolved petitioner from discharge. So, the Supreme Court said that petitioner is correct in stating that the July 26, 1989 decision of the NLRC has attained finality, but the said decision of the NLRC actually dealt only with the money claims of private respondents arising from employer-employee relations and illegal dismissal, and as such, it is only for the payment of the said money. But the administrative sanctions, which are distinct and separate from the money claims of private respondents, may still be properly imposed by the POEA. So according to the Supreme Court, the NLRC decision absolving petitioner from paying private respondents to the MESA's claim for salary deduction based its ruling on a finding that the said money was not raised in the complaint. While there may be questions regarding such finding of the NLRC, the finality of the said NLRC decision prevents us from modifying or reviewing the same. But the fact that the claim for salary deduction was not raised by private respondents in their complaint will not bar the POEA from holding petitioner liable for illegal deduction or withholding of salaries as a ground for the suspension or cancellation of petitioner's license. So they also reiterated that under the POAE rules and regulations, the POAE on its own initiative may conduct the necessary proceedings for the suspension or cancellation of the license of any private placement agency on any of the grounds mentioned therein. So those are the issues, but to summarize, the Supreme Court said that petitioner should be absolved from the 3 counts of illegal exaction as POEA Administrative Circular Number 2, Series of 1983 could not be the basis of the administrative sanctions against petitioner due to lack of publication. However, the Supreme Court affirmed the ruling of the POEA of the Secretary of Labor and Employment that petitioner should be held administratively liable for 2 counts of contract substitution and 1 count of withholding or unlawful deduction of salary. The Supreme Court said that the license of the petitioner should be suspended for 6 months, or in lieu thereof, it should be ordered to pay fine in the amount of 30,000 pesos. Petitioner should also likewise pay the amount of 1,000 to private respondent Vivencio de Mesa as a restitution for the amount withheld from his salary. So that's the decision of the Supreme Court for this case. Thank you. That's it for today's episode, guys. By the way, if you want to get a copy of the full text of the case, highlighting the important details I mentioned earlier, you may want to check this podcast description for the link. Thank you for listening and talk to you next time. Bye!